President Trump has signed orders dramatically reducing the size of two national monuments in Utah, the Grand Staircase-Escalante and Bears Ears. And together, the protected monument lands are being reduced by more than 90%. But this is not only an environmental story. There's a civics standpoint to look at from here. So it's a question about presidential power and the authority of Congress, federal land, tribal sovereignty, and then just who gets a voice in decisions about public places that have deep cultural and historic meaning. So the civics question worth asking today is really, how much power does a president have over public land, especially when it comes to these two national monuments? National monuments are usually created under the Antiquities Act of 1906. And that law gives presidents the power to protect federal land containing historic landmarks, prehistoric structures, or just objects of scientific or historic interest. But the law also says the protected area should be limited to the smallest area compatible with protecting those objects. And that phrase has caused arguments for more than 100 years now. Some presidents have used the Antiquities Act very broadly to protect large, sweeping landscapes. And critics argue that presidents have stretched the law in its enforcement too far. Now, supporters, of course, argue that large areas may be necessary to protect archaeological sites, fossils, sacred landscapes, ecosystems, and just historic resources that can't be separated just neatly into smaller pieces. Grand Staircase-Escalante was first designated by President Bill Clinton as a national monument in 1996. Bears Ears was designated by President Obama, in 2016, after years of advocacy from tribal nations and then also conservation groups. Trump reduced both monuments during his first term, and then President Biden later restored the monuments to about their original size. And that back and forth is where we find the civics lesson. When public land protections can be expanded or reduced or restored and reduced again, depending on who is president, public land policy becomes tied very closely to executive power. And Congress could settle this more permanently by just, passing legislation. The Constitution gives Congress authority over federal property. But when Congress does not act clearly, presidents use power Congress has already delegated through laws like the Antiquities Act. Now, the legal fight is whether the delegated power includes the power to drastically reduce monuments after they've already been created. And the Antiquities Act clearly lets presidents create the national monuments. It's much less clear as to whether a later president can erase or dramatically shrink them without Congress's involvement. And then when you look at Bears Ears, that adds another important layer to this argument too, because we're not talking about it just being scenic land. It is a cultural and sacred landscape connected to the Hopi tribe, the Navajo Nation, the Mountain Ute tribe, the Pueblo of Zuni, and then just the Ute Indian tribe. And those tribal nations helped push for the monument's creation and for a role in protecting ancestral sites, burial places, petroglyphs, ceremonial landscapes, and then just archaeological resources. Treaty questions when it comes to indigenous peoples and Native Americans can be very specific and complicated. So I'm not going to claim, just one blanket treaty violation here without naming the treaty and the right, that's involved here. But apart from a very specific treaty claim, the issue when it comes to civics is pretty clear. So, tribal nations are sovereign governments. They're not just like lobbyists or interest groups or something like that. So decisions about Bears Ears raises questions about consultation, co-management of the land, sacred sites, and then the federal government's trust relationship with Native nations and the indigenous peoples. So now, supporters of the reductions argue that the earlier monument designations locked up too much land and limited local use. Their development, grazing, mining, recreation. Purportedly, there's uranium deposits on these federal lands. Now, opponents to this, of course, are arguing that the reductions weaken protections for the cultural sites, the tribal heritage that's involved here, the possibility of fossil deposits, and then just public land that belongs to all Americans. So, can a president shrink a national monument? And really, that's the legal question. But the civics question is, it's bigger than this. Should millions of acres of public land, including land with deep tribal and cultural significance, depend so heavily on the decision of one president? And really, should Congress just make the rules more clearly? Should they develop better legislation outlining the rules? So I thought that was a civics question worth asking today. There's all kinds of other layers that go into this as to what's going to happen to the land that's been removed from the national monuments. Is that going to be, available for development by corporate interests? Does the state of Utah have a claim on any of this land? Does it just remain federal, and the federal government gets to determine what happens to this land within the state of Utah? Are the tribal interests going to be able to speak up and take these kind of things into a courtroom, perhaps, and try to get the boundaries put back to where they had been? So I don't think this is a situation that is, it's static and just going to stay in place. I look for it to be more fluid in the days to come. Anyway, thanks for watching, and take care.